Ensuring that people are working in the UK legally is now firmly in the spotlight with all employers, large or small. Recently, the construction industry in particular has received a lot of attention from the government about this, reinforcing that every employer, regardless of whether they are a main contractor or a subcontractor, must check their own employees' right to work in the UK. Danjay Damhar, a manager with global immigration company Newland Chase, explains.
October 2015 saw the launch of Operation Magnify, which was a Home Office initiative to visit the construction industry across the UK and stamp out any illegal working. As a result of that, I believe that there were 62 visits to a number of construction sites around the UK, with a number of financial penalties being levied against those construction employers.
The government's guidelines are very specific about the negative impact that illegal working can cause.
Illegal working often results in abusive and exploitative behaviour, the mistreatment of illegal migrant workers, tax evasion and poor housing conditions. It can also undercut legitimate businesses and have an adverse impact on the employment of people who are lawfully in the UK.
The law on illegal working has been updated, and it's now subject to stricter enforcement with heavier penalties. This can be as much as £20,000 per illegal migrant and potential criminal liability for those responsible when illegal workers are found. From a legal standpoint, the Immigration Act 1971 was updated in 2016, and the Immigration, Asylum and Nationality Act 2006, along with the Modern Slavery Act of 2015, also apply in this area. These laws are designed to safeguard people and to make it harder for illegal workers to work in the UK, and easier for employers to employ only those legally allowed to work here. The law on illegal working means that employers need to check the right to work of all potential employees.
The onus of responsibility lies with the employer. The employer is responsible for checking that any of their employees have the right to work in the UK, and if they don't, not to accept them for employment. However, the Home Office do publish a list of all employers that have been found to be employing people illegally, and as part of that list they will also publicly state the location where an illegal worker has been found.
This means that if an illegal worker is employed by a member of your supply chain, your company may be named and shamed if the person was found on your site. So, if you subcontract out, you need to be assured that the companies working for you can demonstrate that they check the right to work of all their employees. Ask them to verify this. If you're in any doubt about an individual case, we recommend that you carry out a right to work check yourself, just to be on the safe side. Better that than to risk a penalty. Similarly, if you are a subcontractor who employs operatives, you need to be able to demonstrate to the main contractor that you have completed right to work checks. So exactly who can work in the UK from overseas without needing a visa? Well, currently, with the exclusion of Croatia, everyone within the European Economic Area, plus Switzerland, can work in the UK without a visa. But they must have a passport or national ID card for identification purposes. It doesn't matter if this ID is expired, as long as they have it and that it is genuine. But please check on Home Office guidelines regularly, because the current situation could be adjusted as our relationship with Europe changes. Work restrictions for Croatians still apply until 2020, when their EU probationary period finishes. This means that they must get permission before they're able to start work, whereas other EEA nationals only need to prove their nationality. When it comes to people from outside the European Economic Area, you need to pay closer attention, as these people will need a visa to work in the UK. So, what are the visa categories? There are many different types of visa, but here are some of the most common ones you're most likely to encounter. Tier 1 entrepreneur visas are for entrepreneurs setting up or running their own business. They are not allowed to work outside their businesses as salaried employees. There is also a Tier 1 general visa allowing unrestricted employment, but this is being phased out. The Tier 2 general visa is where a company sponsors someone from outside the EEA to work for them. There are specific rules and duties regarding Tier 2 sponsorship for both the employee and the employer. Companies need to apply for a license to employ these people on these visas, and then they need to apply separately to sponsor an individual. People on Tier 2 visas can only work for the company that sponsors them. They can't use that visa to work anywhere else. The Tier 4 General Student Visa is designed for international students who may be entitled to work. Generally, they're only allowed to work for either 10 or 20 hours a week during term time and full-time during vacations. You'll need to see proof from the college or university that they're actually studying there and to check the term dates. Once they've finished their course, you will need to check whether they are allowed to continue working. On completion of their studies, a student with a Tier 4 General Visa might want to apply for a Tier 2 Visa, allowing them to be sponsored by the company they've been working part-time for. If so, they are allowed to start working for a company in a permanent post while their application is being processed. The Tier 5 Temporary Work Visa is a useful option for interns and people moving to the UK for a short period. This can include those on a government authorised exchange, but it has to be part of an approved scheme. And don't forget, they must be paid at least the national minimum wage. Other common visas you may see include spouse visas and EEA Family Permit Residence Cards. These allow people to work for a restricted period of time. Also, when people are applying for residency in the UK, they may have indefinite leave to remain, permanent residency or settlement status. This means that there is no time restriction on their stay. Right to work checks are important to carry out properly to ensure illegal workers are not employed and that your existing employees are safeguarded. Now, make sure you view our second video in this two-part series to find out when and how to carry out these checks correctly. Carrying out right-to-work checks. But you should remember, details and laws can change frequently. So it's a good idea to visit the government website and download this helpful free document, An Employer's Guide to Right-to-Work Checks.